for 5 minutes.
Thank you, Mr. Chairman. I'm so glad we're having this hearing today. I've been looking for the opportunity to talk about something that's very important to me about, and I'll be very careful not to disclose anything that's classified. About a month ago, I went back down to one of those skiffs that Mr. Blanton was talking about. You can't take notes out. And what I did is I reread the 28 pages, but I brought the redacted version with me so that I could see in what manner it was redacted. And by the way, I want to ask you guys a question later so you can get ready with an answer, but one of the things that I would think would help is to know the reason for the redaction. Like, there's certain reasons that might be legitimate. It may be a law that says when you redact large swaths or even small portions, that you have to give the reason. If the reason is to avoid embarrassment or to protect a source or to protect somebody who may not be guilty, their public reputation, just disclose it. And then the crime or the infraction could be that you lied about the reason, because that's what I want to get to with these 28 pages and the reason for those redactions. And I think I can disclose my perceived reason for some of these redactions without disclosing anything classified. 20% of the redactions, I would say, were to protect specific and confidential sources. I would say another 20% were to withhold the names of individuals whose reputations would be irrevocably ruined, whether they were guilty or not. But 60% of those redactions fall into a very troubling category for me. They change the very nature of the document and the way it's perceived by the public and the impact that it should have had. For instance, and some of those are probably to prevent embarrassment, but I feel like after reading that 10, 20, 40 years from now when it's all released, this is going to be a textbook case of how the government overclassified something in an effort to control the narrative. In fact, before these pages came out, there was an op-ed in the USA Today by two of the chairmen on the commission that said, these are raw, unvetted sources, right? So the redactions, in my opinion, were made to support that presumption that these were raw, unvetted sources, because if you remove the redactions, you would say, no, those might be credible sources, in fact, and they might, in fact, be vetted. So that's my concern, is that 20 years from now, we'll look back at this. You'll see that keywords and acronyms and sentences were removed. And with the effect of diminishing the impression that you get from reading the unredacted pages, which is that Saudi Arabia, and I can say that name now because it's in the redacted pages, has some kind of civil liability or criminal culpability, either, and not because of their citizens, but because of their government, acted either in I would say, acts of omission or commission. Either one makes them somewhat culpable, and I'm afraid that has been diminished by those redactions, and it's been overclassified, and this is a prime example. So one of the questions I want to ask is, do you think it's a good idea if we required them to give the reason for the redaction?
Absolutely, sir. The order does require original classifiers to be able to identify and describe the damage to national security. But to my formal statement, I attached an actual email that had been used as count one for a felony indictment of Mr. Drake, who was eventually not prosecuted. But the government claimed it was classified. And in preparing for the trial, the NSA was required to state specifically why they considered that email to be classified. Their explanation looked entirely rational when you read it, but if you compared what they said to the actual document, it was factually incorrect.
Right. So that supports the notion that they should be required to disclose
Absolutely.
it, and there should be some punitive ramification for misleading about the reason. Mr. Aftergood?
I would like it to make the point that the classification system is permissive. It says that information may be classified if it meets certain conditions. And what that means is that the decision to classify is actually a subjective one. Somebody thinks that classification is the right move. And because it's subjective, you or I may disagree and say, you know, that's a mistake, you're wrong. And so providing the reason, I think, would be helpful, but it wouldn't necessarily resolve the disagreement. I just disagree with that reason. Instead, I would suggest that in cases of significant interest, like the 28 pages, like many other cases, there needs to be a procedure where you take the decision away from the original classifier. Don't try to make the original classifier admit he was wrong. Take the decision away, take it to a third party. There's a public interest declassification board. There may need to be a new body and say, does this make sense? I want you to evaluate it as a third party and come back to us with a recommendation.
Mr. Chairman, I appeal to let the other two answer the question.
Just very briefly, exactly this mechanism exists for mandatory review requests, this Interagency Security Classification Appeals Panel, and it's ruled in favor of openness over 70% of the time. Just a third party, the simple maneuver of taking the document away from the original agency and putting it in a panel that includes the original agency, you get a completely different result.
Mr. Ames.
And this is also a process with the Freedom of Information Act. There is a process there where just only a few years ago did they add where they had to list the reasons. In the old days, we used to just get a letter back with tons of blackened out markings, and then in the intro they would say we redacted things for, you know, B3, 4, 5, 6, 7. And you had to kind of guess what it may have, what applied to one specific redaction. Now they're required to go through documents subject to the Freedom of Information Act and list right next to each redaction what the redaction, what exemption was being cited to justify the reason for that. And also then you also have an administrative appeal that we always hope that it goes to a different entity inside of the department rather than the person that made that marking. And then now there's also a process through ISOO to challenge those determinations and go to, in essence, an arbitration. And so it's funny that we have a better procedure just for that Freedom of Information Act process than we do for the classification process.
And I've seen those documents with those markings, and they're somewhat helpful because they classify the stuff they even send to us. They try to not even disclose. So, but I haven't seen that on the 28 pages. I've just seen op-eds that say, oh, there's nothing to see here. And by the way, it was released the day before Trump named his vice president, which is another thing, but at least it was released in part. Thank you.
Thank the gentleman. The chair now recognizes Mr. Connolly.